I'm thinking that we'll probably just all stay on because we don't have any hearings between your 9:15 and 9:45. So
Okay, that works.
yeah. I think we do at least. Let's look. Say that. Yeah. Yeah, you're okay. I gotta do this here. Just wait a minute. Love you.
Morning, Council.
Good morning.
Good morning, Your Honor.
Welcome to the 95th District Court. Is this everyone on Adams Kebab and Grills versus Sabre Realty Management?
Yes, Your Honor.
Yes, Your Honor.
Are you ready to begin?
Yes, Your Honor.
Very good. Ms. Rouse, calling DC 1918357 Adams Kebab and Grills, Inc. versus Sabre Realty Management, Inc. Council, before I take announcements, allow me to cover a couple things for the record. This hearing is being conducted via Zoom. However, it remains subject to the open courts provisions of the Texas Constitution. As such, we are broadcasting this proceeding on the court's YouTube channel. The public is welcome to view this proceeding. If you have an interest, all the courts in the state of Texas who have a YouTube channel and therefore are broadcasting remotely can be determined at any given moment which courts are actually online by going to the Office of Court Administration, which maintains a constantly updating list of all courts that are live at any given moment. In addition, the courtroom doors happen to be open. There are no members of the public present, but the doors are open, and so this is available for the public to view. I must caution you, however, that recording of this proceeding by any means, whether by the public or by the participants, is expressly prohibited. There is one record and one record only that comes out of this proceeding, and that is the record that's maintained by the official court reporter of the 95th District Court. Any questions about any of that?
No, Your Honor.
May I take the parties' appearances, and let's begin with counsel for plaintiff.
Counsel for plaintiff, Your Honor, is Cal Hamida, Hamideh, and I'm counsel for the plaintiff.
Welcome to the 95th District Court, Mr. Hamida.
Thank you, Your Honor.
And for the defendants?
Your Honor, my name is Allison Batiste and I represent Sabre Realty Management, Inc., a defendant.
And you're muted, sir.
Welcome to the 95th District Court, Ms. Batiste. Mr.
Thank you.
Zoyes?
Your Honor, my name is James Zoyes, and I represent defendant Northwood Hills Village Shopping Center.
Mr. Zoyes, do you have any dog in today's hunt?
I have not filed anything, Your Honor. I'm pretty much watching today.
Very good. Allow me to begin with a few questions and a few observations. First question is there one and only one petition for plaintiff, the original petition?
Give me 1 second. I believe that is correct, Your Honor. Let me see. From my quick review of my online file, appears that is correct, Your Honor.
Okay. What are the causes of action that are alleged in the petition?
We have alleged, Your Honor, breach of the lease contract and two streams of damages resulting from that. One is the illegal.
I don't need to hear the streams of
all
damages.
right.
Tell me about the causes of action.
Well, the cause of action are breach of contract or the lease contract in two respects. One, by taking the property, and one by destroying the business or terminating the business. And that is our main cause of action. We've also sued for negligence, and we've also sued, I believe, for misrepresentation. And those are the live pleadings from memory, but I'm going to pull up the petition
Well,
just to make
I
double
believe
sure.
it's fraud, not misrepresentation, according to your petition.
You are
Ms. Baptiste, I asked that question because you devote a large portion of your motion for protection to some allegation of conspiracy, and I don't see it anywhere in any of the pleadings. Where in the pleadings is a conspiracy allegation alleged?
Your Honor, I have spoken to Mr. Hamide about it, that that he, in his plaintiff's view, that there's an issue with the new tenant, and that the new tenant sort of, I guess, arranged for this lease with the landlords and the management company. And then when I asked the plaintiff in the corporate reps depot, why do you think that there's some issue? He said he thought that, well, his reason was that he thinks that the new tenant is paying our clients a lot more than what he was paying, and so that we were out. And my issue, or my client's issue for this motion for protection, is that we just don't see why the new tenant is relevant to this case. And we're concerned, especially considering the death threats, that that any more information given to the plaintiff could cause us some serious issues and harm down the road.
Well, you didn't answer my question.
Oh,
Where in the pleadings is anything about conspiracy?
My apologies, Your Honor. I don't think that there is anything in any of the pleadings.
Do the parties understand the scope of discovery outlined in the Texas Rules of Civil Procedure?
Yes, Your Honor.
absolutely.
What do you understand the scope of discovery to be?
If you're asking Defendant Saber, I believe it is anything that could possibly lead to admissible evidence.
I think that's a jumping to a later point. What is the discovery? What is the scope of discovery in the Texas Rules of Civil Procedure?
I believe it's anything related to the claims and defenses in the pleadings.
Mr. Amide?
Yes, Your Honor. If there's a reasonable expectation that the discovery could lead to admissible evidence at trial, it's discoverable. It doesn't have to be determined at the discovery stage that this is admissible evidence, as long as there's an expectation that it could lead to discoverable evidence. And that's been the scope, I think, for about 3 or 4 decades.
Well, Rule 192.3 specifically lays out the scope of discovery. A discovery may obtain discovery regarding any matter that is not privileged and is relevant to the subject matter of the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party. How is conspiracy fitting in any of this?
Your Honor, Defendant Saber does not believe that it does, and that is one of the bases for our motion for protection.
Why did you bury that argument in a novel?
My apologies, Your Honor.
I'm going to be blunt. I'm inclined to strike the motion for protection. It violated the local rules, and if you know there's a term in journalism about burying the lead. You didn't just bury the lead, you hid the lead. I'm going to hold up. I review all this stuff in advance. That's just the first page of your motion after my review. and that's not a good sign. This ostensibly is a motion for protection from a discovery subpoena and an objection to, quote, all discovery related to somebody.
Yes, sir.
Correct.
The first 9 pages of the motion don't address either. They give me a litany of complaints you have about the other side and your client. And Mr. Amita, don't get me wrong. We're going to get to your motion in a little bit. And I've got a similar observation. What are y'all doing in this case?
We're not doing very much because we're not getting anything from the other side, Your Honor. Everything's met with this kind of objection. You know, this is
Well,
simple discovery that we're trying to seek from this tenant. And look at what we've got. Look at what we've got, Your Honor. I've got this motion and I've got her objections.
How is discovery? Well, all right. We're going to address these one at a time. What I saw is two counsel screaming at each other in a whole lot of pages. And trust me, I read this stuff. So you're taking the court's time to scream at each other. I have a theory, and that is the court's job is to let the parties conduct their litigation. But then when the parties invoke the court, you've got an obligation to tell me what the fight is, not give me a litany of we don't like them because, and 9 pages of factual recitation that have nothing to do with the subpoena about which you're seeking the motion doesn't get me there, followed by 150 pages of an attachment. I may be off by a few pages where the subpoena that is the subject of this motion is buried on page 123 of the appendix. I don't understand that. There is a reason we impose page limitations in the local rules. And part of it is this, so you'll tell the court what your fight is about. Now, then there's another issue. Ms. Batista, are you hired to be counsel for Nuve Masada?
No, Your Honor.
Where do you get the authority to make certain claims on behalf of Nuve Masada?
The authority comes from our motion. Our motion for protection is based on other issues. The plaintiff in this case has made death threats not just against Nuve Masada, but also representative of our client. And in addition, the plaintiff has requested a whole lot of documents and information about the new tenant that cause conflicts within our lease within the lease between the defendants and Nuve Masada. And so, it's attenuated, but we're genuinely concerned at this moment.
Okay, I understand genuinely concerned, but I don't understand where, for example, I'm turning to page 13 of your motion. Quote, Nuve Masada asks the court to require Adams Kebab. Where do you get the authority to ask for anything on behalf of Nuve Masada if you're not their counsel?
Yes, Your Honor, you are correct. And that is a misstatement. Sabre is asking on behalf of Nuve Masada.
Since where does Sabre have the right to ask on behalf of its tenant for relief from this court?
Because the information that is the subject of this motion for protection is information that directly impacts Sabre and Sabre's lease between, or the management of Sabre's lease between defendant Northwood Hills and Nuve Masada.
I didn't, I honestly don't understand that. There, are you saying that the landlord has the right to come to court, standing to come to court and assert affirmative claims on behalf of a tenant?
Well, first, Your Honor, I should clarify that I don't represent the landlord. The landlord is Northwood Hills. I represent Sabre, who's the management company.
All right.
I do believe that any party affected by discovery can seek protection from the court.
Any party, I agree, any party against whom there is discovery can seek protection. But what gives your client the right to seek protection on behalf of some unrelated party, other than they happen to have a contract with you?
The information affects Sabre. The death threats involved my client and a representative of my client, John West. And we are concerned that giving the plaintiff any more information regarding this new tenant is going to cause harm to our client and our client's representatives.
All right, now that's a claim on behalf of your client.
Sabre.
I'm
Yes.
asking you where you come up with authority to make affirmative claims on behalf
Yeah.
of somebody who's not your client.
My apologies, Your Honor. We can't make, you're absolutely right. We do not have the authority to make claims on behalf of Nuve Masada. Nuve Masada expressed their concerns to us and we're trying to seek protection. But we do not have authority to seek affirmative claims on behalf of Nuve Masada.
In your motion for protection, you state a series of, and it's paragraph 4 of your motion. You state a number of objections to Adams Kebab's discovery requests. Now, for starters, to the extent that that's a global objection to items A through P, that's overruled because they're not particularized. Did you independently respond to the interrogatories, requests, and other discovery responses by filing or serving, not filing, by serving an objection to the individual request?
Yes, Your Honor. Not all of them, because some of them have not become due yet. But the ones where they were due, we did, and I attached them as exhibits.
I have an issue with that, Your Honor. That is not a true statement.
Okay. Honestly, it's kind of irrelevant to the court at this point in time, whether it's true or not true. Here's a simple fact. I've got an objection, quote, objections to Adam Kebab's discovery requests that lay out items A through P. And they include amongst the boilerplate. Moreover, none of the discovery requests relating to Nuve Masada would lead to the discovery of admissible evidence. Instantly, I can think off the top how some of them might lead to the discovery of admissible evidence. We've got a breach of a lease. We've got I don't know whether we've got an alleged breach of a lease by somebody. We've got a new tenant in that immediately affects damages in some respect by having a new tenant. I'm not saying, I'm not weighing the evidence in any respect, but something may be relevant to something. And when you give me a global objection to A through P and don't tell me particularly what's wrong with that discovery request, it makes the rest of the argument well, irrelevant.
Your Honor,
Mr. Zoyes Mr. Zoyes wants to get into this mess.
Very briefly, Your Honor, I was just going to say, since I do represent the landlord entity, we do not have affirmative breach. We have not asserted a claim against the plaintiff for any future rent or unpaid rent that would be implicated by mitigation of damage. I just wanted to clarify that issue.
Fair enough. I've read the pleadings. And I understand that. And Mr. Zoyes, I totally understand that.
That's all I had to say, Your Honor.
Your Honor, may I respond also?
You may.
Your Honor, the reason why we don't think that this affects damages is because plaintiff's damages involve the property left in the property, the items left in the property at the end of the lease when it was terminated. According to the lease, there's some property that's attached, like vent-a-hoods and HVAC and other stuff of that, the build-out stuff, which the plaintiff got some allowance from the landlord. That stuff does not leave the lease, does not leave the property after the lease. The other property is what the plaintiff is complaining about. And that plaintiff, by the terms of the lease, because he never took it out, never tried to take it out, was abandoned. And so that is what we're talking about right there. And that still has nothing to do with the new tenant.
Okay. You gave me a global answer. Once again,
Okay.
What the court needs and what, frankly, plaintiff is entitled to is an objection. For example, to interrogatory number 24, identify all communications between you and the new lessee concerning the leasing of the property in question.
Okay.
Now, we're not going to do that here.
Okay.
We are not, that they are entitled to a particularized objection because there may be some things to that interrogatory that are relevant to a claim or defense of a party in this litigation. There may be particular matters that are privileged. I don't know what those would be. There may be communications that have no relevance to any claim or defense, but they're entitled to an answer to that, to an objection to that interrogatory. Following that, the first request for production number 30, a copy of all leases of the property after plaintiff's lease was terminated. They're entitled to a response to that, not this global objection.
We have objected. We've given them particularized objections.
Then bring those objections to the court. If it's an issue, bring those objections, not this global objection on top of a motion for protection for a subpoena that got buried on page 10 of your motion.
So, Your Honor, they are attached. Where we would be discussing these in particular would be in the event that the plaintiff filed a motion to compel, then we would go through each of them in particular. But at the moment, I understand it. I get where you're going, and I should have outlined every single particularized objection inside the motion. I attached our responses, which have particularized objections, to our actual responses to the discovery to this motion, and I admit that it was probably because this motion was too long to begin with, as you pointed out, and so I just attached them. But we did make particularized objections to each and every one of them.
Okay, but you didn't bring them to the court.
I did, but they're
on page 153, and then not even doing any reference to them, not saying, we assert this objection doesn't advise the court of anything other than you've got some complaints.
Okay. Your Honor, would you prefer for our clients and for our, for the sake of our client, if we file a separate or an amended and set it for hearing and put the objections inside, and I can rewrite the motion so that it's more to the point?
Here's what the court would suggest very strongly.
Yes.
The motion, Adams Kebab, Sabre Realty Management Inc.'s motion for protection is overruled without prejudice to reasserting it. I understand there's a September 6th response date on the subpoena to Nuve Masada. It's overruled without prejudice to reasserting it.
Okay.
But I strongly urge you, before you bring it back to this court, that you review the local rules, including the attachments about the lawyer's creed, the general order of this court adopting the local rules with the page limitations, and this court's policies and procedures, because this court has laid out this court's view of litigation, particularly in paragraph 2 of the policies and procedures. And then with regard to discovery, specifically, I think it's paragraph 10, talking about the scope of discovery.
Okay.
This court shouldn't have to be involved in this fight between counsel and their parties.
Your Honor, and I agree with you. We did not want to bring this fight to the court. It's just that we have real concerns about this plaintiff. He has made death threats against our client and also the new tenant, and we have real legitimate concerns.
And if you have real legitimate concerns, there are avenues to approach it other than this sort of motion.
Okay, may I ask, Your Honor, what other avenues you would suggest?
I'm not your client's lawyer. I mean, if death threats are being made, there are avenues to approach other than 180 pages of a litany of complaints about them. I mean, seriously, if there are death threats being made, there are all sorts of legal avenues. And I'm not suggesting there were death threats or not, but to throw that into a motion for protection about a subpoena and about some discovery requests is like, where are we going with this?
Yeah.
Well, and that is our question.
Your question to whom?
So, and Your Honor, you are absolutely right that motions are too long. And within there, probably buried, is our issue that we have tried our darnest to talk to the plaintiff about these issues. We have tried to discuss, we've tried to figure out what exactly the issue is with the new tenant. What are we getting at? Where are we going with this? And I have met with no response, and I attached emails. There are many more where I have tried, I've called, I've spoken to him, and I cannot get any other information. And as I've said, Your Honor, we have legitimate concerns when we are going down a path of discovery that does not seem to in any way relate to this case. And we started this conversation in May with a threat that plaintiff was going to make this case in
You're giving me a litany of complaints you have about them that has nothing to do with this motion.
Well, it actually does. We're asking for protection. We're asking for help.
You're asking for protection from a subpoena to some other party and discovery without laying out your specific objections to any of that.
And I will refile I will refile the motion along with the objections and outline the objections within the motion. I apologize, Your Honor. The document was too long. I was trying not to add the objections inside of the document, but you're absolutely right, and I will refile it and we'll get it heard before.
All right. And before you do so,
I will look
you
at.
will have a real conversation
I have.
with, you will, this is going to both of you, because we're going to say the same thing about the next motion. All right. You two will have a real conversation about these things.
Can I say something, Your Honor?
The court has to order you into a conference room and tell you that you don't come out until you've had a real conversation about these things. I'll do it. But
I would appreciate that order, to be honest with you.
All right,
I mean-
I feel like I've got to say something, Your Honor, because my side isn't heard on this particular issue. If you'll allow me, or maybe it'll just be on the motion for
I could
sanctions.
care less about this death threats argument. All right. And honestly, at this point, and don't mean, if your client is making death threats, the court has concern, but that's not what we're here about today. All right. So I suggest you not raise this issue. What I am concerned about is counsel not even talking to each other. Mr. Mide, looking at your motion for sanctions, you put a certificate of conference on the back of it that reads in its entirety, "This is to certify that the undersigned attempted in good faith to resolve issues surrounding this matter without court intervention. Counsel for defendant Saber is opposed to this motion. Therefore, this matter is presented to the court for determination." You gave the court no inclination whatsoever what sort of efforts were made. Did you pick up the phone and have a conversation, real conversation about this motion? Or you told the court nothing? And given what I'm reading, it strongly appears that neither of you had any conversation about the real matters in substance. Secondly, Mr. Amit, all right.
Can I address that just real briefly?
Fair enough. I'll
Real
give
brief.
you a moment.
During the course of the discovery abuse, we have discussed at every interval that counsel's understanding, as you saw from the motion, simply because it's in the lease or her client says so, it is a determined, decided, litigated fact to her. And so I'm not allowed to get discovery on anything that she believes is either in the lease or her client said so. And you can see that in her motion for protection when she says, "My client said," and that's it, that's the King's X. The other thing is, Your Honor, I picked up the phone yesterday and personally called counsel and said, you want a certificate of conference? Let's discuss it. Are you going to agree to any part of my motion, or can we just, and the thing that I got back was all hostile, belligerent. I'm going to file this. Early on, she told us, "We're going to bury you in paperwork. You're not going to be able to withstand this case." I'm a small law firm. It's me and my son and my daughter. And I'm going up against this Goliath, Your Honor. David over here, and she made it known to us in the very beginning, "Hey, you cannot withstand what we're going to bring you." So I did pick up the phone yesterday, Your Honor, and personally called, and I filed an amended certificate of conference yesterday, Your Honor, saying that I personally talked to counsel.
No, Your Honor, please let me.
All right. You know what? Y'all are doing exactly what I said you were doing. And Mr. Mide, you've got a motion for sanctions. You're alleging, in general terms, abuse of discovery, but your motion is particularized as to some service time issues. And the fact that counsel only gave dates that were near the end of the mediation period, but we're within the mediation period. Can you point to a single certificate of service that was signed in violation of either, excuse me, Article 10 of the CPRC or Rule 193?
Yes, Your Honor. Her second attempt at subpoenaing my client's financial records.
Now, slow down. I asked for a certificate of service signed by her that is, because you didn't attach any of them.
What we attached the grid that showed the subpoena date, her signature date, and the date that it was served on us. The fact that it was served on us 5 days after she actually served the deponent takes away my ability to file an objection within the rules. Now 191 gives me 3 days to file that objection. Her signing that pleading is a violation of 215. It's a violation of 21A. It's a violation of the lawyer's creed. That coupled with everything else that's going on. I'm sorry, Your Honor, you have a specific question.
I asked you about a signature on a certificate of service. Can you show the court a certificate of service that says it was served? I hereby certify that the document was served on April the 13th, when in fact it was not served until April the 22nd. That's just an example.
That would be our exhibits, Your Honor.
And none of them have that. I'm sorry, none of them have. I've looked at every one of them.
Well, all right, then I won't go there.
I mean, you're talking about service date, the date the subpoena was issued, the date it was served on you, and nowhere referencing the certificates of service. And then the court has the question, since when does the date she served the subpoena on you impact your right to move for protection?
The date that she serves the subpoena and I get notice of it, I've got 3 days to file an objection, or otherwise my objections are waived.
That's not precisely the rule, but let's say that's the the 3-day rule under certain circumstances. When
Right.
does the 3-day clock begin to run?
When I get notice of whatever she's sending to me.
In other words, when you receive it.
Right.
So how does the date, so how does the date she actually served it deprive you of that 3 days notice period, to the extent there's a 3-day notice period?
Well, you're right. It doesn't deprive me of that because I've got 3 days after I get notice of it. But what it does deprive me of is she served a subpoena on the real estate agent involved in this deal. He gave her the documents and answers before I could object. So that's the fear here, Your Honor. And the other thing is she's trying to subpoena my client's bank records for the last 7 years. Why? What's her reasoning? To find out if he paid his rent. Well, the rent was paid to you. I mean, if that's not sanctionable, I don't know what is. Trying to get my client's private financial records from all of his banks for the last 7 years because she wants to know if he paid his rent. And she attached to her motion the rent ledger that showed each and every single payment of rent for the last 15 months. This is what I'm dealing with. If you see the motion for protection, that's sanctionable. I mean, that conduct, and that's what I'm getting. I filed the first request for discovery, Your Honor. I got objections, got nothing. I followed up more specific with a second request, got nothing. I filed a third request and I got all these objections. So I went to the third party to try to get it, something that I was entitled to get 9 months ago from Sabre. And so all of this extra effort, all of this gamesmanship, stall tactics, and delay, that's cost my client and me so much time, effort, stress, and money. And we don't have, I grew up in the era of the Rambo tactics and everything that the Supreme Court did to do away with that. And I'm seeing it here. There's a pattern. There's a pattern when she deposed my client, Your Honor. She tried to depose him in English when she knew that he doesn't speak any English, but she took a whole hour and harassed the heck out of him. Then they finally got an interpreter and took all 6 hours. So I gave her an extra hour. And after the deposition was concluded, Your Honor, guess what? She says, I'm going to take another 6 hours with him because the other defendant, because we're all together here, I'm going to take his 6 hours. And I said, you can't do that under the rules. And it just goes on and on. And at every turn, we are met with stall tactics, gamesmanship, and delay. And I know this is early on for sanctions. And I know the court's policy with regards to, and I'm not asking for death penalty sanction. I'm just asking for a warning. So in the next 3 months before discovery ends, I can actually get some discovery.
Well, here's my response to that litany of what you just went through. All of that may be true and it may be sanctionable conduct. It may not be. I'm not deciding that right now. What I'm looking at is a motion for sanctions that references CPRC 10, Rule 191.3, and TCRP 13, none of which deal with a pattern and practice of discovery abuse. They all deal with signatures on discovery, and you didn't even, you alleged those, and then you spent 11 pages not telling me about her signatures.
Well, Your Honor, the exhibits do have her electronic signature where she's got certificate of service to me and Mr. Zoids, and it has her signature and the date of the certificate of service on all of the subpoenas, all 7 subpoenas that she's issued. First is the affidavit of service, and then her notice of intent to take deposition has got her signature, electronic signature with the certificate of service, and it has the actual date on it.
Which exhibit are you referring to?
These are the 7 exhibits attached to my motion for sanctions, which are the return of service and her notice with the subpoena on all 7 third-party deponents.
I'm sorry, I'm looking at, for example, Exhibit B to your motion, the automated certificate of service. Is that what you're referring to?
Let's see what this one is labeled. No, that shows the service on the deponent. And I'm sorry,
No.
my motion is, I've got the motion in a separate area and the exhibits in another area, so I'm not. For instance, A, I see what you're referring to, Your Honor. That's A and A2.
No, actually, I'm looking at your motion, Exhibit B, your motion, Exhibit C, your motion, Exhibit D, your motion, Exhibit E, your motion, Exhibit F, your motion, Exhibit G, your motion, Exhibit H, your motion, H. Each one of those is generated by the e-filing system when you're actually served with them. That's not her certificate of service.
Well, I'm looking at something then totally different.
All right. Unless you can show me a signature, electronic or otherwise, that was filed in violation of CPRC 10, 191.3 or Rule 13, I've got to deny the motion. But again, that's without prejudice to showing the court that there is sanctionable conduct.
I will lay out, if this continues, I will lay out a 215 motion, Your Honor. I was really hoping just for an instruction from the court that, as you said, no
Right.
more, you know, let's get
I'm
along.
telling you, there is an instruction from the court, and to the extent that, uh, seriously, this is uncalled for. You are both members of the bar. This is an honorable profession. Your clients may have a fight. I have no idea. They may hate each other. It doesn't matter. You are their lawyers. It is your job to hash these things out dispassionately, and counsel, that's the instruction of the court. To the extent the court has to issue sanctions, it's the last thing I want on a lawyer practicing in this court. It's the last thing I want to do. But you two have an obligation to meaningfully confer on all matters. You can disagree all day long on the matters of substance, but on the matters of procedure, most things should be agreed to. And that doesn't mean that we don't argue on the fringes, but most things on procedure should be agreeable.
Agreed, Your Honor.
Both motions are denied without prejudice to the refiling and rebringing of them. And to the extent, I understand, to the extent that there is a need for the court to rule on the subpoena as to Nuve Masada before September 6th, the court is available. But I will say this, Ms. Batiste, be very careful that you are not bringing claims, that you are only bringing claims on behalf of your client.
Yes, Your Honor, I will.
Mr. Zoyce, do you have anything?
No, Your Honor.
All right.
Enough's been said.
Then counsel, you are excused. Have a very good day.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
I've added them.
Okay.
Ms. Rouse, do you need a few minutes to do paperwork on that hearing?
No, sir, I already have it down. Thank you.
All right, very good. Sorry, counsel, we just wrapped up my 10:15 and 10:45 on the same case.
No problem for me.
Ma'am, what is your last name?
I'm Sarah Spengler.
Okay, thank you.
And I see Ms. Fontaine is also with us in two different squares. Are you there, Ms. Fontaine? As I understand it, she's the one who asked for this this appearance.
Yes, and I spoke to her earlier. She wanted to make sure that I had everything to be on, and I don't know where she is.
And she's not muted, so it must be a technical.
I can send her a message. Yes, she does confirm that she's having technical issues.
She's calling in, I think.
Yep.
Hi, this is Addison Fontaine. Can you hear me?
Yes.
You're very low.
Okay, is this better?
Slightly.
Okay, I apologize. For some reason, I've done multiple Zoom hearings, but for whatever reason at this time, I'm having technical issues.
That's good right there.
Okay, I will, and if you can't hear me, please let me know.
We'll do so. Council, welcome to the 95th District Court. Let me begin with a brief introduction. This proceeding is being conducted according to the open courts provisions of the Texas Constitution, even though it's being done by remote means, including the use of a telephone. As a result, the members of the public are invited into this proceeding. The way we accomplish that is, one, the courtroom doors are open, even though there are no members of the public present. Secondly, this proceeding is broadcasting on the court's YouTube channel. For what it's worth, the Office of Court Administration maintains a constantly refreshing list of all courts that are live at any given moment, and you can click on that link and find out what court and actually go observe any court that happens to be live. That said, this proceeding cannot be recorded. Not that I'm thinking either of you have any intention of recording this proceeding, but it cannot be recorded by participants or by the public. There is one record and one record only that comes out of this proceeding. That is a record maintained by the court reporter for the 95th District Court. Do you have any questions about that?
No.
Okay. Ms. Fontaine, you asked for this hearing. Please identify yourself.
Yes, Your Honor. Good morning. My name is Addison Fontaine of McGuire Woods, and here today on behalf of Bank of America.
Welcome to the 95th District Court. Ms. Spangler?
Spangler.
S-P-I-N-G-L-E-R?
S-P-A-N-G-L-E-R.
Spangler.
Mm-hmm.
All right. Welcome to the 95th District Court. Would you identify yourself?
Thank you. My name is Sarah Spangler. I'm with KB Carlton, PLLC, and I am here representing, sorry, I am here representing Miss Evelyn Williams.
And it's my understanding that Ms. Williams has recently been deceased.
Correct.
Is that correct?
Yes.
All right. Condolences to the court.
Thank you.
Or from the court. Ms. Fontaine, first of all, thank you for your paragraph in your letter regarding candor toward the tribunal. May I ask how it was that the Bank of America learned of these additional beneficiaries?
Yes, Your Honor. After the order granting the joint resignation as trustee was entered on or around, I believe, July 16th, my client was going through documents and reviewing necessary items to allow for the transfer of the assets from Bank of America to the successor trustee, Cypress Trust. And while going through those documents, located a family tree and immediately notified myself and another member of our firm and let us know about the potential of additional beneficiaries. And at that time, we looked into these individuals. We immediately put opposing counsel on notice, and thereafter we contacted all of the additional beneficiaries to confirm, whether or not they were living or deceased, as being alive and succeeding Ms. Williams is a necessary requisite to recover under the trust. So we contacted all of them as well to put them on notice of the trust and also give them information regarding the trust, Your Honor.
How was this not discovered beforehand? I'm just.
Sure, Your Honor. Your Honor, at this time, our client did not know that there were additional beneficiaries. The family tree that we were provided did not have, and I don't have it right in front of me, but it did not have, all of the successors of certain individuals. And Your Honor, my client was not on notice or had not made that discovery. And as soon as my client knew, they ultimately told opposing counsel and put all of the additional presumptive beneficiaries on notice.
Ms. Spangler, do you have any reason to doubt any of that?
I don't. I think they should give us notice immediately.
Is this the proceeding in this court entirely for the purpose of making the court authorizing the resignation of Bank of America and transferring trusteeship to, is it Frost Bank? I don't even remember.
It's
Your Honor,
Cypress.
it's Cypress Trust. And
I'm sorry, can you repeat that? Can you repeat the name?
it's Cypress Trust, and it's CYPRESS Trust Company.
Thank you.
I mean, is that the sole purpose of this litigation?
Well, Your Honor, it's to, for administrative reasons for Bank of America to resign as trustee and then transfer the trust assets to Cypress Trust, Your Honor. And, prior to our discovery of the additional beneficiaries and prior to the recent passing of Ms. Williams, the parties were in agreement of this to facilitate the transfer of the assets in that fashion.
Again, that is the sole purpose of this litigation, is to effectuate that resignation of Bank of America and the transfer of the trust corpus and the trusteeship to Cypress, correct?
Yes, Your Honor.
How does the existence of any of the beneficiaries, whether they've been put on notice or not, really impact the trust?
So it does not specifically impact the trust or the assets of the trust or the final amount of the trust, but in accordance with specific provisions of the trust code, we have to put all of the adult remainder presumptive beneficiaries on notice prior to resigning of the trust. And at the time that the order allowing Bank of America to resign, we had included what we thought all of the additional beneficiaries in the petition to put them on notice to otherwise appear. As background, a number of the beneficiaries we took default against because they did not appear in this action after being put on notice. But at this time, we just want to make sure that this court does not require us to refile the petition for resignation as trustee and put the other additional beneficiaries on notice out of an abundance of caution.
Okay. Spangler, does Ms. Williams or I guess her estate have any position on that whatsoever?
Your Honor, actually, we have not opened an estate for Ms. Williams.
All right.
At this time, we don't have a reason to, unless there's a reason to in this particular action. But to answer the question, no, she had no objection. She was perfectly happy with removing Bank of America. Cypress Trust Company is actually located in Florida, where she was located. And so that was easier for her, and she was very happy to agree.
And if I'm reading between the lines, at the time I want to get the name of it correctly, order granting joint petition was presented by Ms. Williams and by Bank of America. Everyone was in agreement that all I's had been dotted and all T's had been crossed. Is that
Yes,
correct?
Your Honor.
Yes, Your Honor.
Does Ms. Williams' subsequent passing affect the order granting joint petition?
Your Honor, I don't believe it does. She was in agreement with the transfer of control over to Cypress Trust. I think the only reason that we are here is just because of the additional beneficiaries that may have affected the court's decision to grant that order had they known.
That order was signed on July 16. When did she pass away?
Early August. I don't know the exact date, either late July or early August. Addison, you may actually have her date of death, do you?
Yeah, I believe it was July 26th.
Okay.
Do I understand correctly that the corpus now is to be distributed to the beneficiaries?
Yes, Your Honor.
All right. What's easiest? Transfer it to Cypress or just distribute the corpus to the beneficiaries?
Well, Your Honor, Bank of America spoke with Cypress recently, and they are aware of the passing of Ms. Williams. They're also aware of today's hearing and the matters to be discussed herein. They also advised that they made the decision to continue in the capacity as successor trustee, and are fully aware of the fact that this was a triggering event to terminate the trust. I don't know if it's a matter of what's easier. I do believe that prior to Bank of America, of course, passing the trust assets to the Cypress Trust, we would just want a court order saying that, pursuant to the recent order granting the resignation of trustee, that Bank of America is no longer the trustee, Cypress is the trustee, and then we'll transfer the assets, and then they would then deal with the dealing out of the assets to the remainder beneficiaries.
Ms. Spangler, do you have any objection to that?
I do not, Your Honor. I have also spoken with Cypress Trust, and they have agreed and reiterated their commitment to finalizing the trust, taking the assets from Bank of America and distributing and terminating the trust that way. So they're happy to do it.
Can I get a commitment from you, Ms. Fontaine, that upon the presentation of that order and the signing of that order, the Bank of America will put both the named defendants and the additional beneficiaries on notice of the presentation of that order?
Yes, Your Honor, and I will say that the only remaining named defendant, I believe, is Ms. Williams. So it would be Ms. Williams and then the additional beneficiaries.
Okay. Fair enough. I have no objection to signing an order allowing or acknowledging the resignation of Bank Bank of America and authorizing the transfer of the corpus to Cyprus.
Your Honor, would you like us to draft a joint petition and get that on file this week?
That would be delightful. And I'll tell you
Okay,
what, I'll tell you what I suggest. If it's possible, just set it, call the clerk. Once you get it on file, set it for placement on the Monday 8 a.m. submission docket. The court now has a submission docket Mondays at 8 o'clock. Just present that, and I'll have some notes from this that I will consider that at that time. If you can, if you get it this week, set it on this coming Monday's submission docket. If you get it filed next week, get it set on the following Monday's submission docket. So.
Yes, Your Honor. And I just have a couple more housekeeping matters, if you don't mind.
Don't mind.
I just wanted to confirm whether Bank of America should correct the pleadings with respect to the prior representations that all of the, beneficiaries were represented in the prior pleadings, or if this status and the subsequent order will be sufficient.
Your letter requesting this hearing is on file. It's pretty clear. You might want to file an amended petition just to have that clear, so that if someone's just looking at the pleadings rather than the letter, that there's absolute clarity on that. I mean, you might want to do it for your protection and the bank's protection.
Yes, Your Honor. Okay. Well,
But the court doesn't have an opinion on that. All right. I'm thinking this through from your standpoint. So please proceed.
Yes. Yes, Your Honor. And I believe as of, on my end, I believe that answers all the questions I have. I don't know if Ms. Spangler had any questions for the court at this time.
Do you?
I don't.
All right.
We're good.
Very good. Well, the court remains available to provide any guidance and assistance that you need to bring this to a close.
All right. Thank you, Your Honor. And I apologize for my technical difficulties this morning.
All right. We all, I was in a major hearing last week and got kicked off by the county's Wi-Fi 3 times in the middle. So I understand.
Okay. All right. Thank you, Your Honor.
Thank you.
Thank you, Your
Y'all
Honor.
have a great day. You're excused.
Bye-bye.
Bye. Thank you.
All righty.
She needs to go away on that one.
Let me see. When is our next?
I'm actually removing.
Oh, okay. Let me turn.
I'm trying.